So, very good evening, friends. Let us discuss section 29A. Section 29A is quite lengthy section. It basically talks of persons who are not eligible to be a resolution applicant. So it says a person, and the definition of person we have to see from section 3, I think. It must be given in section 3. Because person includes company, individual, HUF, everything. So accordingly, we have to see the definition of person. So person, I think, includes almost everyone. So this definition is given probably in section 3. Yes, section 3, subsection 23 talks of person, individual, HUF, company, trust, partnership, LLP, any other entity. So everything. So it says a person shall not be eligible to submit a resolution plan if such person or any other person acting jointly or in concert. Now this definition of jointly or in concert is given in SEBI regulations basically. Basically the intention, when the intention is the same, they want to take over a particular company and the intention is same, it is established that they are acting in concert or they are acting jointly, then connected persons also are not eligible. So first point is an undischarged insolvent. Now let us see who is an undischarged insolvent. Suppose a company is under CIRP. Now, whether that company can be said to be undischarged insolvent? This is the first question. So it says the NCLT stated that while a company is under CIRP, it cannot be undischarged insolvent. Because the disqualification is for undischarged insolvent. So it says he will not be eligible if he is an undischarged insolvent. Now a company is under CIRP. So basically, although it is not an undischarged insolvent, but definitely it will be under the control of an insolvency professional, IRP or RP. And IRP or RP cannot fritter away the assets of the company because they are used for the benefit of the stakeholders. So I don't think a company under CIRP will be allowed to be a resolution applicant. But we can discuss it further in the group. I think although technically it is eligible, technically there is no bar because it is an undischarged insolvent. So it is not a company, it is not an undischarged insolvent if it is undergoing CIRP because no adjudication has yet been made. Willful defaulter, the definition of willful defaulter is given as per RBI website. You can find out whether a person is a willful defaulter or not. Third is regarding NPAs. NPA, it has been classified as NPA and it is so for at least a period of 1 year. Because after 1 year of the classification of an asset as NPA, it is moved from substandard to loss asset. Then it says, provided that the person shall be eligible to submit a resolution plan. But suppose a person or a company in which he is a promoter is having some NPA account and he pays all the overdue amounts with interest and charges relating to NPA accounts before submission of resolution plan, then still he is eligible. Provided that nothing in this clause shall apply to a resolution applicant where such applicant is a financial entity and is not related to the corporate debtor. So if it is a bank or a financial institution, then this clause will not apply if it is not a related party. And the related party will not include a financial entity regulated by a financial sector regulator if it is a financial creditor of the corporate debtor and is a related party solely on account of conversion or substitution of debt into equity or instruments convertible into equity shares prior to the insolvency commencement date. Suppose it is a banker. Bank is having redeemable convertible debentures. Those redeemable convertible debentures at the time of maturity were converted into equity shares. and it has become a related party by virtue of section 524 because it is holding more than 2%. So although it is a related party, but it being a financial institution, it is not covered. Second is NPA acquired pursuant to a prior resolution plan. You are a company, you are an asset reconstruction company, you acquired some company and 3 years have not passed from the date of approval of such a resolution plan. Then also, although you might be having some NPA accounts because the company which you bought, you have acquired all the assets and liabilities of that company. Now, some of the assets of that company might be NPS, which might not have yet been paid or repaid. So in that case, this ineligibility will not be attracted if 3 years have not elapsed till from the date of approval of resolution. If you are prohibited by SEBI from trading, but suppose you are issued a show cause notice. So show cause notice alone is not a bar. You should be prohibited. It should be prohibited. You should be restricted from, say, trading. You were charged of insider trading. You were issued a show cause notice, and SEBI found you to be a defaulter, and they prohibited you from trading in securities or accessing the securities market. Then naturally you are ineligible. But simply you have been issued a show cause notice, then you can be a resolution applicant. Next is you are a promoter or in the management or control of a person in which this PUFE transactions took place. Order of the adjudicating authority also came. Then also you are not eligible. But suppose you acquired a company, you are a resolution applicant in some other company. That resolution plan was approved. In that company which you acquired, there were some PUFE transactions, but you were not a party to those transactions. You did not contribute to those PUFE transactions. Then also you are eligible. Next is if you have been convicted for any offense punishable with imprisonment for 2 years or more under the act, any act specified under the 12th schedule. So 12th schedule basically talks of this Foreign Trade Development Regulation Act, RBI, Central Excise, Prevention of Food Adulteration, Essential Commodities, Securities Contract Regulation Act, Income Tax. 12th schedule, I've given it in the PPT, which I've shared from section 1 to 30. With this, basically, these are the various acts. There are 12 acts in this schedule. Environment Protection, Sikh Industrial Companies Act, Air Prevention and Control, Conservation of Foreign Exchange, Water Prevention and Control, Customs Act, Income Tax, Securities Contract Regulation Act, etc., etc. So, if you have been convicted of any offense, then also you are ineligible. But the conviction should be for 2 years or more. So list given specifying 25 acts and a residue clause for insertion of more acts, or for 7 years or more under any other law for the timing in force. Suppose you were convicted of an offense involving moral turpitude and you were sentenced to imprisonment for 7 years or more, then also you are not eligible. For any of these economic offenses, basically 2 years period is there, and for other offenses for any other law 7 years period is more. But suppose you were sentenced to imprisonment and 2 years have elapsed since you came out of the prison, then also you are eligible. If you are disqualified to act as a director under the Companies Act, then also you are ineligible. If you have executed a guarantee in favor of a creditor, but this point is very specific. This clause is very specific. It talks of execution of a guarantee. Suppose you are a resolution applicant. You have executed a guarantee in favor of a creditor in respect of the corporate debtor against which an application for CIRP has been admitted. Suppose a company is undergoing CIRP. Okay. You had executed a guarantee in favor of the creditor of that company which is undergoing CIRP. That guarantee was invoked and it remained unpaid in full or part. That means you were also responsible in some way because you were financially not able to fulfill your commitments in respect of that guarantee, so in that case also you are ineligible. But this clause does not apply to MSME. This clause and clause C regarding NPS, these two clauses, they do not apply in case of MSME units. Achha, next is subject to any disability corresponding to clauses A to H under any law in a jurisdiction outside India. So even if outside India you have been convicted or you were prohibited, suppose in India it is SEBI, in other countries it is Securities Exchange Commission. So if you are prohibited by Securities Exchange Commission, then also you are not eligible. And clause J, it talks of a connected person, not eligible under clauses. Connected person has got its own definition. Basically, the promoter or holding company or subsidiary. Connected person means any person who is in the promotion, who is the promoter or in the management or control. Any person who shall be the promoter means the intending promoter. You submitted a resolution plan. In that resolution plan, you stated that such and such person will be the promoter. So anyone who is going to be a promoter in future, so that is also a connected person, or the holding company, subsidiary company, associated company, or related to any of the above. But such clause also does not apply to a financial entity, and if it is not a related party of the corporate debtor. Financial entity also has been explained as to what is the financial entity, a scheduled bank, any entity regulated by a foreign central bank, then any investment vehicle, foreign institutional investor, provided they are registered foreign portfolio investor, etc., etc. So there is a long list. So all these persons are not eligible to be resolution applicant. Now let us see each of these clauses. You can even take a pen and paper and you can keep on noting down. So PNB, one of the financial creditors of XYZ. So one of the important things here is PNB. PNB is one of the financial creditors of XYZ. It filed an application under Section 7 of IBC. The application was admitted on 15th of September. This is an important date because there is a reference to this insolvency commencement date at various places in Section 29A. So you have been appointed as a resolution applicant for XYZ Limited because it is the responsibility of the resolution applicant to see whether it is the responsibility of the resolution professional to ensure that the resolution applicant is not suffering from any of the disqualifications. But whatever resolution plans have been received, he will put it before the COC. Even if it is an ineligible candidate, he will specify that, okay, this is the ineligible candidate and it is for the COC to decide the seriousness. And last date for submission of resolution plan is 14th of December. Now, pursuant to request for resolution plans, 8 plans were received by you. The staff deployed by you, I think we put 9 conditions. So let's say 9 plans were received by you. And the staff deployed by you for a preliminary screening has raised the following red flags. He says, sir, I find some issues in these resolution plans. So let us see what are the issues. So PRA1, prospective PRA here stands for prospective resolution applicant. He says the first resolution applicant is undergoing CIRP. So if it is undergoing CIRP, then although he is not an undischarged, he is not an undischarged insolvent, but still, because the board stands suspended during CIRP, board doesn't have any power. And it is through the resolution professional, the company is operating. So in all probability, the COC will not be agreeing for any such resolution plan for such person. Another inability could be due to those NPAs. There may be some defaults, etc., etc. Second, prospective resolution applicant, it is a promoter of ABC Limited whose account is classified as NPA on 20th of September 2020. Now let us see whether it is eligible or not. So account was classified as NPA on 20th of September. 2020. And what is the insolvency commencement date? The insolvency commencement date is 15th of September. So whether he is eligible or ineligible, this person. Shirish Atlekar ji is asking which clause is not applicable to MSME. The two clauses 29C and H. 29A, C and H are not applicable. C pertains to these NPAs and H pertains to execution of guarantee, invocation of guarantee. So both clauses C and H are not applicable to MSME, and it is given in section 240A, and it says the in respect of any company which is undergoing CIRPs. If you go to section 240A, so section 240A says notwithstanding anything to the contrary contained in this code, the provisions of clause C and H of section 29A shall not apply to the resolution applicant in respect of CIRP of any MSME. So CIRP should be of MSME. So we have to see the company which is undergoing CIRP, not the resolution applicant. Yes, eligible. So Tripti Morej is saying it is eligible because 1 year has not elapsed. Right. So once again, if we see 29A, 29A is saying at the time of submission of the resolution plan. So the last date for submission of resolution plan is 14th of December 2021. So this inability has to be seen at the time of submission of resolution plan. And the opening sentence of this 29A also says a person shall not be eligible to submit a resolution plan. So the ineligibility has to be seen at the time of submission of resolution plan. So the time for, suppose he submitted on last date only, 14th of December. So from 14th of December, we have to see. So this is 14th of December, 14th of December 2021. And account was classified as this on 20th of September. Okay. So from 20th of September till 14th of December, whether 1 year has passed or not. 1 year तो हो जाएगा मैडम. हाँ तृप्ति जी, होगा नहीं 1 year?
हाँ सर 1 year हो जाएगा.
हो जाएगा ना? हाँ. तो आपको देखना कब है? एट द टाइम ऑफ सबमिशन ऑफ रेजोल्यूशन प्लान. अलग अलग जगह अलग अलग लिखा हुआ है. समटाइम्स इट इज रिटन द डेट ऑफ द रेजोल्यूशन प्लान, बट हियर इट इज रिटन द from the at the time of submission of the resolution plan, and we will presume that whatever is the last date, on that date plan was submitted. So 14th of December and 20th of September. So on 20th September 2021 को ही पूरा 1 साल हो गया. अब इससे तो ज्यादा ही हो गई. अगला चलते हैं. तो अखिला रानी जी is saying yes, 1 year has passed. ठीक है. अच्छा, नेक्स्ट देखिए, नेक्स्ट रेजोल्यूशन एप्लीकेंट क्या है? थर्ड रेजोल्यूशन एप्लीकेंट, ही इज अ रजिस्टर्ड फॉरेन वेंचर कैपिटल इन्वेस्टर. So whether a registered foreign venture capital investor is included in the term financial entity, if we see the definition of financial entity in 29A, this is given at the last, explanation 2. And explanation 2 says, for the purpose of this section, financial entity shall mean. So here it is included foreign venture capital investor is included. So registered foreign venture capital investor is included, and he was having 5% redeemable convertible debentures of rupees 2.5 crore in PQR Limited. The authorized, issued and paid up capital of PQR is 100 crores. Acha. Or 5% redeemable convertible debentures of PRA3 were converted into equity shares of rupees 2.5 crore as on 1st of September 2021. Now, whether my question, first question is whether this prospective resolution applicant is a related party of PQR Limited or not. First question is this. You forget about this 29A. If we are not seeing 29A, whether because it is holding more than 2% of equity share capital, but equity share capital of PQR is 100 crores. Out of 100 crores, he is holding shares worth 2.5 crores. So he is holding more than 2%. So he is a related party of PQR Limited. But now the question is whether he is a related party of XYZ Limited or not. Question here is this. It is conversion. नहीं तो आंसर क्या है इसमें? What is the answer? Whether eligible or not eligible? भाई PQR लिमिटेड का क्या कनेक्शन है? कुछ कनेक्शन है इससे? इससे तो कोई कनेक्शन ही नहीं है XYZ से.
हाँ तो रिलेटेड पार्टी नहीं होंगे ना.
Yes, रिलेटेड पार्टी नहीं होगा वो. It is eligible, ठीक है. तो श्री शटलेकर जी आप इसके बारे में बोल रहे थे कि नो? किसके बारे में बोल रहे थे आप?
No, no. I'm sorry. You are correct.
देखो भाई हमें कंपनी का नाम भी देख लेना है. ऐसा नहीं कि भाई खाली परसेंटेज देख लिया और हो गया. वो कंपनी डिफरेंट है, ये कंपनी डिफरेंट है. ठीक है ना. नेक्स्ट देखते हैं. PRA4. So PRA4 prospective resolution 4 it is an asset reconstruction company. ठीक है. Now it acquired M&M Limited on 15th of October 2018 pursuant to an approved resolution plan. It is an asset reconstruction company. It keeps on purchasing companies, and it is frequently a resolution applicant, and it goes on acquiring companies. So they acquired this M&M Limited on 15th of October pursuant to an approved resolution plan. The assets acquired included NPS, so they must have acquired NPS also, which are still NPS as on 14th of December 2021. Now, whether this is eligible or not, because it says there is a proviso in 29A(C), and the proviso says.
Explanation 2, sir.
Yes, explanation. Explanation 2 says, for the purpose of this clause, where a resolution applicant has an account or an account of a corporate debtor under the management or control of such person, or of whom such promotion is a promoter, and such account was acquired pursuant to a prior resolution plan approved under this code, then the provisions of this clause shall not apply to such a resolution applicant for a period of 3 years from the date of approval of such a resolution plan. So the date important here is the date of approval, and 3 years have to be counted from that date. So date of approval was 15th of
15.
October. So from 15th of October, 3 years you have to count. So 3 years will be completed on 14th of October 2021. But these accounts are still NPAs on 14th of December. So whether it will be eligible or not?
Not eligible.
Yes, not eligible because 3 years have elapsed. The
Yes.
relaxation which was given 3 years, that is also over. If not eligible. Now let us see next. This prospective resolution applicant 5, he was arrested for adulteration hoarding under the Essential Commodities Act 1955 and was convicted for a period of 1 year. Whether eligible or not?
Eligible.
Because yes, it is eligible because the punishment here is 2 years or more under
Yes.
any act specified under the 12th schedule. So he is eligible. And prospective applicant 6, let us see. He failed to file annual statements consecutively for a period of 3 years and was removed under section 164(2). Whether eligible or ineligible?
Ineligible, disqualified to act
Yes,
as
he is disqualified to act as a director under the Companies Act. But here, if I say that he failed to file annual statements, but whether disqualification has to be given by MCA specifically by removing his name, or simply failure to file annual accounts will entail disqualification. Suppose he did not file financial statements for a period of 3 years, but no action has been taken by MCA. Then what will be the position?
So simply not filing makes him disqualified.
It is saying is disqualified to act as a director. So I think this will attract disqualification. Next applicant is a listed company and has been issued a show cause notice by SEBI. Whether eligible or not?
So
What the clause
it
says?
is eligible.
Yes, it is eligible
Is
because the clause
is-
says is prohibited. So he is not prohibited. He has
Prohibited.
just been issued a show cause notice. So show
Yes.
cause notice may be decided either way. So only if there is a specific prohibition by securities, and prohibition also should be from trading in securities or accessing the securities market. Only then this disqualification is there. And even if it is in some suppose some foreign securities exchange commission, he was prohibited, then also he will be attracting this disqualification. Next prospective resolution applicant, he says he has acquired JK Limited pursuant to a resolution plan submitted by आज भी रिकॉर्डिंग शुरू नहीं किया लगता है ना?
सर किया था आपने?
किया था, बस ठीक है,
हाँ.
ठीक है. तो PRA 8, he has acquired JK Limited pursuant to a resolution plan submitted by PRA 8. The erstwhile directors of JK Limited, they were involved in various PUFE transactions as per orders of the adjudicating authority. However, PRA 8 has no role in it. So in this case, whether PRA 8 is eligible or not. So he has acquired another company which was subjected to some PUFE transactions. But those frauds were done by the erstwhile directors. Now, this company, which is the prospective resolution applicant here, he has acquired that company. So in this case, whether he is eligible or not?
Eligible.
Eligible, yes. Next, PRA 9. So PRA 9 is a 100% export oriented unit and has investment in plant and machinery worth rupees 100 crores. Now, so first of all, we have to see whether this company is a MSME or not. Whether this company is MSME or not.
Not, sir.
Why?
Medium.
50,000 है ना, 50 crore है maximum ये, और turnover 250.
Turnover is not turnover, it's investment in asset is 250. Does not exceed 250 crores. It's a medium scale. It is a medium enterprise.
इन्वेस्टमेंट ये तो आ जाएगा मेरे हिसाब से. क्या क्या मीडियम का क्या क्या है? व्हाट इज द क्राइटेरिया?
250 investment in plant and machinery does not exceed 250 crore,
Hmm.
and share capital does not exceed 50 crore.
Share capital या turnover? Turnover होगा.
Turnover 250 है sir.
50 crores.
टर्नओवर तो अब टर्नओवर तो ये ऐसा ना कि 100% एक्सपोर्ट ओरिएंटेड यूनिट है तो टर्नओवर विल बी नील
Oh,
फॉर एमएसएमई पर्पस बिकॉज इट डज नॉट इंक्लूड एक्सपोर्ट्स. सो एक्सपोर्ट इज एक्सक्लूडेड फ्रॉम टर्नओवर. जो भी टर्नओवर होगा उसमें से एक्सपोर्ट एक्सक्लूड करते हैं हम. तो ये तो 100% एक्सपोर्ट ओरिएंटेड है. तो टर्नओवर फॉर द पर्पस ऑफ कैलकुलेशन ऑफ एमएसएमई क्राइटेरिया इज नील इन दिस केस. सो इन्वेस्टमेंट इज द ओनली क्राइटेरिया एंड इन्वेस्टमेंट के हिसाब से इट विल बी एमएसएमई आई थिंक. Now, ठीक है, once it is MSME, now they have executed a guarantee in favor of PNB in respect of XYZ. So both the criteria are fulfilled. This CIRP is of XYZ Limited. CIRP has been initiated by PNB. And PNB they invoked the bank guarantee on default by XYZ Limited. And this guarantee executed by PRA, it remained unpaid in part by PRA. So whether it is eligible or not.
ineligible.
Why?
It does not, sorry, eligible. It does not apply to MSME.
Yes, because so had it been some other unit, then he would have been ineligible. But now, since it is an MSME, so it is eligible despite this qualification. This qualification, because 29A C and H do not apply to this MSME units. So I will be sharing this with you, and based on this, you can fill it in this table, and you can write your remarks also. So let me share it with you. So you can post it in the group after you finish this. अच्छा केस स्टडी वाले में है ये. Just a minute. So now we discuss something about this section 29. If you have any question regarding section 29, you can ask. Or I will ask you some questions now.
Sir, can you explain again?
What? What do you want me to explain? The entire section 29 or what? Or any particular clause? Ajay?
Sir, can you explain that question number 9, sir, again, please?
Question number 9? Okay.
Yes, sir. The second part, sir.
Actually, this PRA 9, this prospective resolution applicant is 100% export oriented unit. So once it is saying export oriented unit as an investment in plant and machinery, then something rings in our mind. Okay, it must be referring to some MSME. So we have to first see the criteria which is applicable for MSME. MSME specify that up to certain turnover and up to certain investment in plant and machinery, you can be classified as MSME. Since it is 100% export oriented unit, and in turnover, you have to exclude the turnover which is export. Suppose 200 crores is the turnover and 100 crores is the export turnover. Then the turnover for the purpose of calculation of MSME will be 100 crores only. And investment in plant and machinery, that also has to be taken as per the ITR as written down value. So since it is a 100% export oriented unit, so turnover is nil. And investment plant and machinery is 100 crores. So somebody was saying it is medium. I have not checked, but must be medium. Okay. So it is a
Sorry, sir. I have the network connection, so I couldn't follow you.
no
properly.
issues, no issues, no
Yeah.
issues,
Right.
no issues. So that is why I'm explaining it to you again. No issues. So this
That's
is
what-
so first once it is established as MSME, then now you have to see this clause again. There is a specific type of resolution applicant which is restricted under this clause 29H. So what should be the type of client? Such a resolution applicant must have executed guarantee. And that guarantee must have remained unpaid in part or full. And not that any guarantee. The guarantee must have been given in respect of that company whose CIRP has commenced. And the beneficiary of the guarantee must be the creditor of that company, which is undergoing CIRP. Suppose PRA 9 has given 5 bank guarantees. So in respect of all, it will not be taken for this purpose. For the purpose of seeing 29, any eligibility under 29AH, we have to look for only those guarantees which were given in respect of this company only, which is undergoing CIRP. And that too, in respect of which it was initiated by that applicant only in whose favor this guarantee was given. Because PNB was the applicant in this case. Suppose some OC applied for insolvency of XYZ, then also this clause would not have been applicable. So it is very specific because it says, this 29A says, has executed a guarantee in favor of a creditor, and not every creditor, in respect of a corporate debtor against which an application made by such creditor, not every creditor, made by such creditor has been admitted, and that application must also have been admitted. So it is very specific type of guarantee which is indicated here, and such guarantee has been invoked by the creditor and remains unpaid. So here it is fulfilling all the conditions. Guarantee was given. Guarantee was given in favor of PNB. PNB filed an application. PNB invoked the guarantee. It remained unpaid. But still, despite all these disqualifications, since it is an MSME, this clause is not applicable.
Okay,
this.
sir. Fine, sir. Fine, sir. Thank you very much, sir.
That is the point actually.
Yes, sir. Now understood, sir. Thank you.
Now, let us see this. I hope my screen is visible now. Understanding the insolvency and bankruptcy code.
Yes, sir.
Yes. This is a beautiful book by IBPI. So let us see some of the provisions. So I'll point it out the important provisions to you. I've noted down certain things. This is quite simple. Let me see something else. Time. Dispute. These are all simple concepts which you all know. Provision for mutual settlement. Let us see this section 12A. What does section 12A says? So section 12A says that applicant only can move the application. Section 12A, as you all know, is regarding withdrawal of application. In this, they have written an article on provision for mutual settlement after the admission of a case under the code. Suppose an application has been admitted under the insolvency and bankruptcy code, and still the payment has been made and they want to mutually settle the dispute after the application has been admitted. So now what are the provisions for that? So this is following the amendment of the code, section 12A of the code read with regulation 30A. So along section 12A, all we know that it requires 90% majority by the COC to, if they want to file an application for withdrawal. And with section this 12A, we have to read regulation 30A also. So let us read regulation 30A. In the PPT I have given you, I think it must be including that regulation also. This regulation 30A is regarding withdrawal of application. It says an application for withdrawal under section 12A may be made to the adjudicating authority before the constitution of the committee by the applicant through the IRP. So there could be two situations. First is when COC has not been constituted. Application has been admitted, but COC has not been constituted. Because as soon as application is admitted and IRP is appointed, he does a public announcement and he invites claims, and based on the claims, he constitutes a committee of creditors. But suppose although application was admitted, but COC has still not been constituted, then in that case, what he will do? So before the constitution of the committee, this application for withdrawal can be made by the applicant. Applicant means a person who initiated the application under, say, section 7 or section 9 or 10 through the IRP. So he can move an application through the IRP before COC is constituted, and after the constitution of the committee by the applicant through the IRP or the RP, as the case may be. Provided that where the application is made under clause B, it means after the constitution of the committee, after the issue of invitation for expression of interest under regulation 36A, the applicant shall state the reasons justifying withdrawal after issue of such notice. So there are, say, three stages. First is when application has been admitted, but COC has not yet been constituted. In all the cases, application will be moved by the section 12A. Section 12A clearly says that the application can be moved only by the applicant. So whosoever initiated the CIRP, section 12A says the adjudicating authority may allow. So may allow means it is the discretionary power of the adjudicating authority, may allow the withdrawal of the application admitted under section 7 or 9 or section 10 on an application made by the applicant. So the application has to be moved by the applicant, and still it is the discretionary power of the adjudicating authority whether to allow such a withdrawal or not, with the approval of 90% voting share of the COC in such manner as may be specified. And then it talks of regulation, because as may be specified means the regulation. And regulation, related regulation here is regulation 30A. So it talks of three scenarios. First, when COC has not been constituted, then by the applicant through IRP. And after the constitution, by the applicant through IRP or RP, provided that. And then also we have to see, well, suppose COC has been constituted, then we have to see whether the issue of invitation for expression of interest under regulation 36A has been made or not. So in this case, if an issue of invitation for expression of interest has been made under regulation 36A, then the applicant shall state the reasons justifying withdrawal after issue of such invitation. Okay, this is just like cancelling marriage after these wedding cards have been printed and people have been invited. So after the issue of such invitation, if you want to withdraw, if you want to move an application for withdrawal, then you have to justify the reasons. And the application under sub-regulation 1 shall be made in form FA. Form FA is the form for this. So they can even ask for the form, and it should be accompanied by a bank guarantee towards estimated expenses incurred on or by the IRP for the purpose of regulation 33 till the date of filing of the application under clause A of sub-regulation 1, because some expenses might have been incurred till the time of withdrawal of application. IRP was appointed, COC was constituted. Suppose it took 15 days, 1 month. IRP must also have charged some fees, some expenses might have been incurred. So towards estimated expenses incurred on or by the IRP till the date of filing of the application has to be made in form A accompanied by a bank guarantee. Or towards estimated expenses incurred for the purposes of clause AA, AB, C and D of regulation 31 till the date of filing of the application under clause B of sub-regulation 1. Acha, where an application for withdrawal is under clause A of sub-regulation 1, the IRP shall submit the application to the adjudicating authority on behalf of the applicant within 3 days of receipt. Suppose COC has not been constituted, then in that case, the IRP will submit the application to adjudicating authority on behalf of the applicant who moved the initial application under 7, 9 or 10 within 3 days of its receipt. And where an application for withdrawal is under clause B, it means after the constitution, then the committee shall consider the application within 7 days of its receipt. Because committee is only considering application is being moved by the applicant through IRP or RP. And where the application referred to in sub-regulation 4 is approved by the committee with 90% vote share, the RP shall submit such application along with the approval of the committee to the adjudicating authority on behalf of the applicant within 3 days of such approval. So in this case, COC has to approve the application with 90% of vote share, and RP will submit the application along with the approval to the adjudicating authority on behalf of the applicant within 3 days of such approval. And the adjudicating authority may by order approve the application submitted, and where the application is approved, the applicant shall deposit an amount towards the actual expenses. So in this case, the question is of furnishing of bank guarantee prior to moving the application. Along with the application, bank guarantee has to be submitted towards estimated expenses. And once an application is admitted, then the applicant shall deposit an amount towards the actual expenses. Because in this case, suppose the application was withdrawn, so whatever were the expenses incurred during that period, so who will be responsible? So till the date of approval by the adjudicating authority as determined by the IRP or RP, so within 3 days of such approval, in the bank account of the corporate debtor, failing which the bank guarantee received shall be invoked without prejudice to any other action permissible against the applicant under the code. So there could be a case study. I will also try to make a case study on that tomorrow. And in the meantime, you can study all these provisions. So this is a very important section regarding this section 12A. And in this IBBI also says, कि following the amendment to the code, section 12A of the code, regulation 30A provides the manner in which IRP can be withdrawn. Since the insolvency resolution process is a proceeding in REM, typically the approval of nearly the entire committee of creditors, they are saying with approval of 90%. However, where the committee of creditors is not in existence, an application may be made to the adjudicating authority for its directions. Even where the COC approves the withdrawal, the adjudicating authority may intervene in the case of an illegality or abuse of process. So the ultimate discretion is of adjudicating authority whether to allow approval or not.
Sir, may I ask question?
Yes, yes, yes.
सर ये प्रैक्टिकल केस है, मैं पूछना चाह रहा था, अगर आईआरपी मना कर दे कि वो एप्लीकेशन नहीं सबमिट करेगा तो क्या होगा?
कौन एप्लीकेंट?
नहीं, एप्लीकेंट, जैसे मैं प्रैक्टिकल एग्जांपल आपको देता हूँ। एक केस में हुआ था और दिल्ली के ही आरपी थे, बड़े नामी आरपी हैं। क्या हुआ, एक रियल एस्टेट कंपनी में बायर ने केस किया, पुराना कि उस केस में
होम बायर ने केस कर दिया, ठीक है
जी।
ठीक है, तो home buyer was the applicant. Home buyer was the applicant in this case.
Home buyer was the applicant and the case was admitted by the NCLT.
No, I think the question you want to ask is, even though COC approves, if the application is not moved by the applicant.
No.
Huh.
In this case, IRP was playing foul.
Okay.
I mean, he was not willing to file application. Then he booked some unnecessary expenses in crores. In 30 days, he booked the expenses of crores. In spite of both the parties agreed, I mean, the real estate developer and the home buyers agreed that they will file for the withdrawal of the case. He insisted that no, it should not be done. It cannot be done. So in those cases where the IRP does not cooperate, I mean, can he really do that? Mera question more hai.
Basically, there are two parties, COC and the applicant.
COC was not formed, sir. COC was not formed. He was trying to form the COC, but it was not formed.
Okay. So then this is governed by regulation 30A, sub-regulation 1. So an application for withdrawal under section 12A may be made to the adjudicating authority before the constitution of the committee by the applicant through the IRP. So it says that the application has to be moved through the IRP. But suppose IRP is not willing to move the application. Okay.
Yes.
Then naturally the applicant itself will move to the adjudicating authority.
I mean,
then, because COC is not there, only applicant is there.
Okay.
And suppose whatever was the grievance of the applicant, that was satisfied. Suppose the company made the payment or company made the allotment to that applicant and he doesn't want to pursue the case further. But IRP is not willing, he might be having his vested interest. Then in that case, the applicant will approach the adjudicating authority.
That can be done.
Definitely. For anything, whatever is not written in the code, adjudicating authority can always be approached for directions.
Thank you.
Because IRP or RP may be having his vested interest, वो सोच रहा होगा मेरा बिल चलता रहेगा अपना.
हाँ, वही हुआ था actually.
हाँ, वही ना. अच्छा, this is another important aspect, liability of guarantors during CIRP. Now, what is the liability of guarantors? Regarding liability of guarantors, there are 2-3 things. Number one, the liability of the guarantor is coextensive with that of the borrower. And it is not necessary to first proceed against the principal debtor. Application can be moved directly against the guarantor. There could be 1 or 2 more scenarios. Number one, the principal borrower is an individual. Principal borrower is not a corporate person, but the guarantor is a corporate person. Because suppose an individual availed the loan and guarantee was given by a company. Then also against the guarantor, application can be moved under section 7. So even though the principal borrower is not a corporate person, but if the guarantor is a corporate person, because guarantor steps into the shoes of the debtor in this case. So section 12A says कि अच्छा ये तो हो गया liability of guarantor. And in this case, we have to see section 60 subsection 2 also. And section 60 subsection 2 basically says that if a company is already undergoing CIRP and there is a guarantor also, then the proceedings against the guarantor will also be will also be entertained in the same NCLT. So 60 subsection 2 of the code says where a CIRP or liquidation proceeding is pending before NCLT, an application related to insolvency or liquidation or bankruptcy of a corporate guarantor or personal guarantor of such corporate debtor shall be filed before the NCLT. Given this, there is legislative clarity that concurrent insolvency proceedings can be maintained in respect of the corporate debtor and a guarantor. So it is the sweet will of the creditor whether he wants to move first against the corporate debtor or guarantor or both. And suppose there are more than one guarantor, he can move against all. But suppose all the guarantors have given guarantee for the whole amount of loan, then in case an application is admitted against one, then the second application will not be entertained because the amount which is being claimed is only one. Earlier, there was some confusion whether these proceedings should be initiated under DRT, but now the things are clear. Okay, proceedings in relation to personal guarantor or corporate guarantor in respect of a guarantee given for a corporate debtor will be entertained only where the registered office of the corporate debtor is situated.
सर एक क्वेश्चन था,
हाँ जी पूछिए।
आप जैसे बोल रहे हैं कि amount admitted if the guarantee is given for the whole amount. If a bank has given a loan of say 100 rupees and against the principal guarantor, principal debtor, admitted amount is 100 rupees. Can we proceed against the corporate guarantor separately or not?
Please repeat your question.
If see ABC को हमने 100 रुपए का लोन दिया,
Okay, ठीक है।
ओके, और XYZ लिमिटेड ने उस लोन की गारंटी दी,
ओके, ठीक है।
ठीक है, और 100 रुपए ABC के लिए एडमिट हो गया सेक्शन 7 में,
ओके,
ओके, तो कैन वी प्रोसीड अगेंस्ट XYZ आल्सो सेपरेटली और नॉट?
Actually, there is no
because ABC लिमिटेड कभी 100 रुपए पूरे नहीं वापस कर पाएगा।
नहीं, वो नहीं देगा तो क्या है, ऐसा है ना, देखिए ऐसा है, गारंटर इज नॉट एब्सॉर्ब्ड ऑफ हिज लायबिलिटी इवन दो रेजोल्यूशन प्लान हैज बीन अप्रूव्ड। तो उस केस में क्या होगा, सपोज देयर आर टू कंपनीज, ABC इज द प्रिंसिपल बोरोवर एंड XYZ इज ए गारंटर. Now ABC Limited has committed a default of 100 crores, out of which through resolution applicant only 60 crores could be recovered. So for balance, the proceedings can be initiated against the guarantor.
सर क्या होता है, ग्रुप ऑफ कंपनीज में एंटायर ग्रुप गोज डाउन, ओके, क्रॉस गारंटीज होती है, क्रॉस कंपनी ट्रांजैक्शन, टाइम इज ऑफ द एसेंस. Okay, for example, if we have lent money to a weaker entity of a large group, okay.
नहीं, ये वाला ना, यहाँ एक मिनट पहले यहाँ से थोड़ा सा इसको पढ़ लेते हैं, उसके बाद में फिर हम कर लेंगे तो काफी चीजें क्लियर हो जाएंगी. पहला क्या बोलता है, वो बोलता है अंडर कॉन्ट्रैक्ट लॉ ए गारंटर्स लायबिलिटी इज कोएक्सटेंसिव विद दैट ऑफ द प्रिंसिपल बोरोवर. So surety liability is not removed by reason of the creditor's omission to sue the principal debtor. Now the situation one could be that the principal borrower is a software company. The creditor also knows that they don't have any assets. So why they will move, while they will waste their time first against the principal borrower, they will directly move against the guarantor. The creditor is not bound to exhaust the remedy against the principal debtor before suing the surety, and a suit may be maintained against the surety though the principal has not been sued. So this could be situation number one. So situation one is principal borrower not touched, guarantor directly sued. the liability of principal debtor and the liability of the surety are separate and coextensive liabilities. Notwithstanding the fact that they may stem from the same transaction, the two liabilities are distinct. Now, second answer. Accordingly, it is possible to proceed against either the guarantor or the principal debtor in the first instance or against both. So
Okay.
all these possibilities are there. If the claim is successful against the guarantor, suppose whatever was to be recovered was recovered from the contractor, the guarantor steps into the shoes of the creditor. Then the guarantor can claim this money from the principal borrower on behalf of whom he paid this money and can proceed against the principal debtor, which is known as subrogation. भाई गारंटर का कोई कसूर तो नहीं है ना, गारंटर ने भाई प्रिंसिपल बोरोवर द क्रेडिटर चोज टू सू द गारंटर फर्स्टली, ठीक है ना, उसको पता भाई ये इसके पास कोठी वगैरह है, डायरेक्टर है, दे हैव गॉट residential property worth crores of rupees, company doesn't have anything, so they will directly move against the guarantor. Now once guarantor has paid, then the guarantor will step into the shoes of the creditor and they can proceed against the principal debtor, which is known as subrogation. So now they can claim the money in case it is recoverable. So it can be either way.
नहीं, if for example अपने example में ABC Limited में there was a property which was secured,
ठीक है,
right? And we decided to move against XYZ Limited, who was the corporate guarantor.
ठीक है, ठीक है.
So rule of subrogation में he becomes a secured creditor at ABC Limited also.
Naturally, whatever were the rights of the creditor, now he has got all those rights against the principal debtor.
Okay.
ये right of subrogation तो यही है ना, he will step into the shoes of the creditor as if he is the creditor now, because he has paid on behalf of the borrower. So he now steps into the shoes of the creditor and he can proceed against the principal borrower. So he, in essence, he becomes the creditor now.
Okay. Okay.
So this was regarding the guarantor. Now let's see the conclusion. The liability of the guarantor is considered to be coextensive with as well as distinctive from the liability of the principal corporate debtor under the code. Accordingly, both the principal corporate debtor and the guarantor can be proceeded under the against under the code. The guarantor can also be proceeded against under different fora when the corporate debtor is being proceeded against under the code. Suppose there is a proceeding going on against the corporate debtor under IBC, then the guarantor can be proceeded under some other law also, say under civil code, because section 14 doesn't apply to the guarantor, it applies to the corporate debtor. Proceedings against the guarantor, whether it be personal guarantor or corporate guarantor, can go on independently. In the alternate, the guarantor can be proceeded against the code, even when a corporate insolvency resolution process has not been initiated against the principal debtor, and even when the principal debtor is not a corporate person. Suppose principal debtor is an individual and guarantor is a corporate entity, then also application can be moved under IBC. However, two corporate guarantors cannot be proceeded against simultaneously. Next is assignment of debt of related parties.
Okay. Normally, sir, what happens is you take the, in case of a guarantees, you take the personal guarantees of all the promoters also, and the main holding company also. So you are saying simultaneously we can't move against all the personal guarantors and all the companies.
No, you can move. There is no bar as to moving against the, suppose there are 10 guarantors, you can move against all. But suppose the amount is one only, then once an application has been admitted, then the other applications have to wait. The other application will not be entertained. भाई पैसे तो एक ही लेने हैं ना, सपोज 100 करोड़ लेने हैं, या तो आप बोरोवर से ले लो या गारंटर से ले लो, गारंटर में ऐसा भी हो सकता है ना, दे मे बी पार्ट गारंटीज आल्सो. सपोज 50 crore was guaranteed by one person and 50 crore was guaranteed by another person, then there is no problem. But suppose the total amount is 100 crores and one guarantor has given guarantee for 100 crores. You moved an application against him. That application has been admitted. Then the other applications will not be entertained. That is the point.
Okay. This is unfair on the part of the financial institution. Because
Right?
sir, क्या होता है कि जब एक ग्रुप की
No, no,
हालत
no.
खराब होती है.
But the thing is that if you are not able to recover fully, suppose you were not able to recover fully from one personal guarantor, then you can move against another.
Sir, it takes a lot of time.
Yes,
till
वो तो
that
time तो
time
है ही
they-
minimum.
फिर जो है उनकी फाइनेंशियल कंडीशन फर्दर डिटेरियोरेट हो जाती है.
Yes,
जब तक उनका
वो तो है ही.
रहेगा तो
वो तो whatever is written in the law is there.
okay.
Next is regarding this assignment of debt of related parties. Actually, you must have read this case of Synergy Dure. Synergy Dure, they assigned their debt to some other company. Suppose there is a related party. And this, I'll show you one case study for this. Let me show you some case study. So suppose in a company, in a private limited company, father X and his son, they have 40% shareholding. And other 3 persons are there who hold 60% shares. Now, management constitution is of X and Y. They are directors. Okay? The other persons, there are 3 directors. Now, both X and Y, they only invested around 25 crores for the business, out of which 23 crores are shown as debt in the business. The major shareholder, by virtue of majority shareholding, have taken control and management of the entire operations. Now, as things are going drastically against X and Y, they approach us for solution. Now, we have advised them to move NCLT as they are the major financial creditor, 92% of total debt. NCLT admitted the case and 2 hearings have gone by. We now have to appoint IRP in COC. But as both X and Y are related parties, they cannot vote because they are the directors in this company. Now they are thinking, suppose there are some directors, you know, now they are apprehending that they will lose control. So what they can do, can they assign their debt? Because they are related parties. If they are related parties, they cannot come into COC. I hope you must have understood the question. The question here is, suppose there are directors in a company, they have given loan also to the company, but despite having given loan, they are. हाँ जी.
सर ये केस लो दिख नहीं रहा आपका स्क्रीन पे शायद.
Just a minute. ये मैंने आपको let me share this. अब देखिए, अब दिखाई दे रहा होगा मेरे ख्याल. आई होप नाउ इट इज.
हाँ अब दिखाई दे रहा सर. और
हाँ.
शायद पढ़ने का मौका देना पड़ेगा आपको अब.
हाँ 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 हाँ,
ठीक है सर।
यहाँ से देखिए। तो इसमें क्या है, द क्वेश्चन इज, इन ए प्राइवेट कंपनी, लिमिटेड कंपनी, फादर एक्स एंड हिज सन, दे आर शेयर होल्डर, दे होल्ड 40% शेयर होल्डिंग, ठीक है। देयर आर सम अदर 3 persons, दे होल्ड 60% शेयर्स। मैनेजमेंट कॉन्स्टिट्यूशन में क्या है, एक्स वाई 2 डायरेक्टर है एंड अदर पर्संस 3 डायरेक्टर्स, ठीक है। Now both X and Y, they only invested around 25 crores for the business, out of which 23 crores are shown as debt in the business. So they have 2 crores as capital and 23 crores as loans from directors. ठीक है. The major shareholders, by virtue of majority shareholding, they have taken control and management of the entire operations. ठीक है. Because the shareholding was limited, now the things are going drastically against X and Y, and they are approaching us for solution. We have advised them to move NCLT as they are major financial creditors. So total, out of total debt, they are having 90% of the debt they are having. NCLT admitted the case in 2 hearings. We have now to appoint, as both NXY are related party, as per section 21 of IBC, they cannot vote in COC because they are directors and they've given loan to the company, but they cannot be part of COC. Now they are thinking whether they can assign this debt or not. This is the question. So what are the questions? Suppose they assign this debt, because as director and having given loan to the company, they can never come in COC. And if they don't come in COC, then decision may be taken against them. Although notice will be given to them being directors, but still there is a possibility so that some adverse view could be taken by the members of the COC. Now they want our advice whether we can assign this debt to some asset reconstruction company. So what are the possibilities? This is the question. Now let us see the what does this IBBI say on this. I hope now it is visible. So it says, okay, this assignment of debt. I'll show you the conclusion. I think conclusion is more important. So it says the assignment of related party debt results in the assignee having the same rights and disabilities as those of the related party assigner. In this case, in the case study which I show you, X and Y both are directors and they have given loan to the company. Now, because they cannot be included in COC, they are thinking of assigning their debt to some other company. But it says the assignment of related party will not have any effect because the assignee will also become related parties. The assignment of related party debt results in the assignee having the same rights and disabilities as those of the related party assigner. Because it says undisputedly, the assignment is the transfer of one's right to recover the debt of another person as a contractual right. Rights of an assignee are no better than that of the assignee. ऐसा नहीं बोल सकते कि भाई हमारे पास तो right नहीं है, we cannot become part of COC, but if we assign the debt to you, you will become the financial creditor and you can take part in COC. No, because the assigner is a related party, assignee will also become a related party. Rights of an assignee are no better than those of the assigner. It can therefore held that assigner assigns its debt in favor of an assignee and assignee steps into the shoes of the assigner. The assignee thereby takes over the right as it actually did and also take over all the disadvantages by virtue of such assignment. What cannot be achieved directly by Mr. This, he did it indirectly, assigning his debt in favor of the first applicant. So Mr. being the related party, with the assignment of the debt, the disadvantage also goes to the other party, to the assignee. I hope it is clear now. तो असाइनमेंट से भी कोई फर्क नहीं पड़ेगा. वो जो हमारा केस था वो पहला केस था, इसलिए उसमें जो हो गया सो हो गया, बट नाउ इट इज नॉट सो. So a case study might come on this also. Acha, regarding treatment of home buyers. Regarding treatment of home buyers, I asked you a question. Okay. There could be a property related transaction, but still the person or the company may not be treated as home buyer. Everybody in a property transaction is not a home buyer. Suppose their land is owned by a person. Okay. And he enters into a development agreement with the other party that, okay, you develop the land because I have got the land. It is my ancestor land, but I don't have the finances. You develop the land and you give me some flats. Now the question is whether the person, whether the landowner can be considered as home buyer or not. This is the question. There is a land development agreement between a landowner and a developer. The developer agrees that in lieu of the development, he will give some flats to the landowner and he will sell rest of the flats. This is the agreement. So whether the landowner can be treated as home buyer or not, the answer is no. He is a operational creditor only. He is not a financial creditor. Recently, this Noida Authority case, Noida Authority was trying to say that we are the financial creditors, but ultimately they were held to be operational creditors, not financial creditors. Let me explain it to you through some other situation. Suppose Mr. X wants to buy a flat in from a builder. Now the builder says, okay, you take the loan from the bank and I will be paying the EMIs. The home buyer is not paying anything. Whether in such a scenario, whether that home buyer, whether that person who availed the loan can be treated as home buyer? No, he cannot be treated as home buyer because he did not pay. Actually, payment of some money has to be there from the side of the person who wants to be treated as home buyer. This is the crux of this treatment of home buyer. Let me show you. अगर उसने पैसा ही नहीं दिया तो कुछ नहीं होगा.
सर नॉर्मली क्या होता है 10-20% तो मार्जिन मनी देना ही पड़ता है.
हाँ, however it is.
And it is the liability of home buyer at the end of the day because the loan is sanctioned in his name. Though builder may enter into a tripartite agreement where he will say that I will pay the EMI.
I will show you the facts of the case. It is significant to note that merely being a home buyer would not automatically bring the home buyer with it. The home buyer is one, financial creditor is another. Because we are treating home buyer at par with the financial creditor. So there could be a scenario where he could be a home buyer, but he could not be a financial creditor. It says merely being a home buyer would not automatically bring the home buyer within the purview of the term financial creditor. There has to be an actual debt that is owed to such home buyer payable by the infrastructure builder company for the purpose of the code. There is a case in the matter of Ajay Walia versus Sun World Residency Private Limited. The home buyer had entered into an apartment purchase agreement with the builder, as well as a supplementary agreement which gave the home buyer an option to cancel the purchase of the apartment within 24 months from the date of disbursement of the home loan by the bank. The home buyer, the bank and the builder, they entered into a tripartite agreement. They can make a case study on this, by virtue of which the builder was supposed to pay the EMIs to the bank. In this case, the EMIs are being paid by the bank for the first 23 months from the date of disbursement of such loans. However, such payment was not to be construed as reducing the liability of the home buyer in any manner. The tripartite agreement further provided that in the event of occurrence of default under the agreement, which would result in the cancellation of allotment as a consequence, and or for any reason whatsoever, if the allotment is cancelled, any amount payable to the borrower in the event would be paid to the bank instead, because bank has disbursed the loan and would be construed as a valid discharge of the builder's liabilities towards the home buyer. When the home buyer cancelled the booking and later on the builder defaulted in payment of EMIs, the home buyer approached the NCLT कि भाई इसकी CIRP शुरू करो against the builder company. Here the NCLT observed that since the home buyer had subrogated all its rights in favor of the bank, he could not be treated as financial creditor. So there could be a situation where there is a home buyer, but he is not a financial creditor. So given that home buyers were not given rights to initiate CIRP or participate in the process as members of the COC, there was a concern that their interest would not be adequately safeguarded. Accordingly, ad hoc safeguards were imposed by the courts in different rulings. To settle this issue, home buyers have now been deemed to be financial creditors by amendment to the code and are members of the committee. But there could be a scenario, अपनी जेब से 1 रुपया भी नहीं खर्चा तो वो फाइनेंशियल क्रेडिटर नहीं बनेगा फिर. Here this situation. Treatment of statutory dues. Regarding statutory dues, let me ask you a question. Suppose gratuity is payable to you under the terms of the employment. Gratuity, leave encashment is payable. Whether you can move an application under section 9 or not. Basically, you can claim this amount, the retirement benefits, when a company is under CIRP, but CIRP cannot be initiated on this basis alone. Suppose you are not paid wages or salaries, then you can initiate CIRP, but not for those retirement benefits. This is what is the crux of this article, treatment of statutory dues under the code. In respect of the CIRP, section 520, and this is a publication of the IBBI, section 5 subsection 21 of the code defines the term operational debt as a claim in respect of the provisions or of goods or services, including employment, or a debt in respect of payment of dues arising under any law for the time being in force and payable to the central government, state government. So while the definition of operational debt include dues arising and payable to government, there was lack of clarity on whether this would include statutory dues. So in this case, ultimately statutory dues were also included.
Sir, whether for gratuity as an OC we can initiate proceedings?
No, we cannot initiate, but once a company is under CIRP, we can put claim for these things. I will show you.
ये तो फिर तो सैलरी और वेजेस का भी तो सेम ही होगा ना सर?
हाँ, सैलरी बेसिस के लिए हो सकता है.
सैलरी वेजेस के लिए भी तो क्रेडिटर नहीं होगा ना वो, क्योंकि सैलरी वेजेस तो वो 53 सेक्शन में अपने आप प्रोपोर्शनल बेसिस में आ जाएगा ना.
नहीं, वो तो आ ही जाएगा, बट ये है कि फॉर दैट सपोज अभी तो खैर अर्लियर 1 lakh was the limit, and even for salary and wages you could have approached you could have moved an application under section 9. There are cases where an employee moved an application under section 9 and that was admitted.
Okay.
Although they say why you should go in for arbitration or conciliation, you have to see the employment agreement. If employment agreement contains arbitration clause, then they advise, NCLT also advise, why don't you go in for arbitration? Why you are coming here? Because it is not a recovery mechanism. Now things have changed. Abhi to 1 crore ka limit ho gaya, so it is not so essential. And here also they are saying there are one or two more things also. When a company is under CIRP, so whosoever are the employees, there may be two types of employees. There may be employees who are working. If they are working during CIRP period or during liquidation period, then their salaries or wages will have to be paid first as per this 53(1)(a). So it is treated as insolvency resolution process cost or liquidation cost. वो 24 months वाला criteria उन पर नहीं लगेगा. There could be two types of employees, but a company is under CIRP. Some of the employees might have left the company. I know they are still on the rolls of the company, but they are not working. So there has to be a distinction between the employees who are working during CIRP or during liquidation and those who are not working. Those who are not working, उनका तो insolvency commencement date के हिसाब से वो treatment हो जाएगा 24 months या in case of workers and 12 months in case of employees. But those who are working, they will be paid first. Dissenting financial creditors. Regarding these dissenting financial creditors, let me ask you a question. Suppose voting is going on a resolution plan. There are three types of persons. First, those who are voting for the resolution. There are some who are voting against the resolution plan. And there are three who are not saying anything. They are abstaining from voting. So those who abstained, where they will be considered? So it says those who abstained would be considered as dissenting financial creditors. So to suppose we want to calculate 66% because 66% is required for approval of resolution plan. So suppose there are some persons who abstained from voting, then they will be considered as if they have dissented to the proposal. And there are some others, financial creditors who are not part of COC, because there might be some financial creditors who are not part of COC, maybe some related parties. So they are neither dissenting nor assenting. This is also important. Applicability of section 29A we have already seen. I think we can stop here and this ye bhi complete ho hi gaya hamara pura. If you have got any questions, you can ask. Otherwise, we can meet tomorrow.
सर ये न्यूज़लेटर शेयर कर दो क्या?
हाँ न्यूज़लेटर शेयर कर देंगे, बिल्कुल बिल्कुल अभी शेयर कर देता हूँ, बाद में मुझे भी याद नहीं रहता.
ठीक है सर, थैंक यू.
ये न्यूज़लेटर नहीं है एक्चुअली, ये कोई बुकलेट है उनकी.
ठीक है सर.
इंसॉल्वेंसी
और जो कल जो न्यूज़लेटर दिखाया था वो भी शेयर कर दो.
वो कर दिया ऑलरेडी शेयर ग्रुप में.
ओके,
अभी कर देता हूँ, दोबारा कर देता हूँ, मेरे ख्याल तो कर दिया मैंने.
ठीक है सर, थैंक यू.
नहीं तो ऐसा है, आपको कुछ ना मिले आप वहां ग्रुप में लिख दिया करो, ग्रुप में वो लोग दूसरे भी शेयर कर देंगे, कोई इशू नहीं है.
ठीक है सर.
सर कोई ऐसा ये रेगुलेशंस जो हैं इनका कोई सेपरेट बना हुआ कि ये रेगुलेशन हमारे को इजीली पढ़ने के लिए जरूरी है? प्रैक्टिकली तो बहुत होते हैं.
नहीं सारे ही पढ़ने हैं सर, सारे ही पढ़ने हैं जी. ऐसा नहीं है कुछ. वो तो मैंने उसका कंपेंडियम भी शेयर किया है आपसे. मैंने ग्रुप में आई शेयर द कंपेंडियम.
सर लोग चाहते हैं गेस कर दिए सर, गेस कर दिए चाहते हैं लोग.
क्या
लोग चाहते हैं कि गेस कर दीजिए कि कौन कौन आएगा.
Guess मतलब? हाँ जी
बता दीजिए कौन कौन से क्वेश्चन आएंगे सर.
नहीं देखो, मैं तो आई कीप ऑन राइटिंग इन द ग्रुप के व्हाट इज इम्पोर्टेंट व्हाट इज नॉट, और मैं ये भी बताता रहता हूँ भाई स्पेसिफिकली स्टडी दीज टॉपिक्स, बस वही इंपॉर्टेंट होते हैं और क्या। अभी ये वी आर आल्सो ट्राइंग टू एसिमुलेट थिंग्स, और बाद में जो है ना सारी आपको केस स्टडी बना के हम लोग दे देंगे इस तरह से ना। थोड़ा डिस्कशन भी जरूरी है केस स्टडी के साथ साथ ना। ये इन डिस्कशन से भी ना बेसिकली तो क्या है, पॉइंट्स शुड बी, देयर शुड बी क्लैरिटी। अभी बेसिकली वी आर स्टडिंग दिस CIRP, तो CIRP में जो भी कुछ आपके क्वेश्चंस हैं उनको कर सकते हैं। टुमारो प्रकाश कुकरेजा जी विल बी टेकिंग दिस सेशन, ही इज एन इंसॉल्वेंसी प्रोफेशनल, तो टुमारो ही विल बी टेकिंग दिस सेशन। ठीक है सर, गुड नाइट।
Thank you, sir. Thank you.
कोई क्वेश्चन हो तो पूछ सकते हैं, नहीं तो राम राम।
Thank you, sir.